Morning, everybody. Thanks for joining us again. I think today we're going to have a discussion which is quite interesting in respect of schemes under administration or schemes that need to go under administration. It's not something that one wants to see for schemes to happen, but it does happen in the industry, and we're seeing from our side at Stratafin, we're seeing it more and more. And I think some of the stuff that we will be discussing is the reasons why we're seeing this, which includes what's happening at the municipalities. I think that is a large cause of that as well. So we'll have a chat about that, and also some misconceptions regarding administration. We'll just throw that in as well, so that people understand what can happen and what can't happen when a scheme is under administration.
All right. Can you see it? Okay. All right. Good morning, everyone. I'm just going to do the introduction of our speakers for today. First up, we got Willie, who is the CEO of Stratafin. For those that haven't met him yet, Willie is has practiced as a property attorney for 20 years. He was involved in sectional title management for over 8 years, where he's dealt with various municipal bills, interacted extensively with local municipalities. Willie started Stratafin in 2014 with the goal of assisting body corporates with their funding without catching them in a debt trap. Stratafin strives to be a fair and equitable money provider for the sectional title industry. Hendrik hasn't joined us for a while, so nice to have you with us, Hendrik. Hendrik holds a BCom law degree. He's been involved with local municipalities for over 20 years, working as a town secretary manager for corporate services within various municipalities. Hendrik served as the town secretary for Heidelberg municipality and as an executive manager for corporate services for the Lesedi municipality. During his time at the municipalities, he oversaw council and mayoral committee secretariat, legal department, HR, IT, public facilities, municipal public accounts committee, tender committee, various standing committees. He has in-depth knowledge of all these processes and legislation governing local government. So he has extensive knowledge here. Veronica Bhengu, she studied at Northwest University, Vaal and Potchefstroom campus, and respectively holds a BA law degree and an LLB degree. She's completed her articles of clerkship and is admitted as an attorney of the High Court. Veronica is well versed in sectional title and homeowners association legal compliance. Veronica sees herself as a pioneer in the community scheme industry, speaking at various recent events such as NAMA, educating the industry on administration in terms of Section 16 of the STSMA. Veronica was appointed as the Director of Confiance Administrative Solutions in February 2022, where she administers sectional title buildings in distress and has had huge success so far. We look forward to continuing and enjoy the session.
Thank you very much, Lauren, for the introductions. Thank you, Willie, for welcoming our guests. And we can get right into the topic. I think, Lauren, I'm supposed to be on slide 4 at the moment. Please.
Okay, great. Okay, jokes.
All right. Thank you, Lauren.
Sorry about that. Thank you.
No problem. As a sectional title administrator in terms of Section 16, we see sectional title schemes having a huge array of problems. And in the first part of the section, we will discuss the reasons why a scheme should go under administration, or indicative factors of how schemes struggle, and you'll identify that as the trustees maybe on the webinar will identify these mistakes or these issues, managing agents as well. I think they will relate, and our solution into curing the issues that the scheme has. So I'll break it down, I'll make a few examples so that it's a little bit more relatable, and we can have a conversation on how these issues manifest in schemes. And to kick off, the first one, which is the pain in most schemes, is the financial instability. And we see that this is primarily caused by the non-payment of levies. This increases the levy debt book. I'll make an example. If a scheme has 10 units and only 10 owners are paying their levies, we all know it's near impossible to run a scheme with a collection rate of 10%. So you will see that schemes that or where owners are not paying their levies, they will fall into arrears with their creditors, like the local municipality. They'll fall into arrears with the security, garden services, maintenance, and so on. And the big pain here that we see is that if you fall into arrears on your local municipal accounts, the scheme will disconnect. And this is very problematic. And secondly, we see that in schemes where there's a disconnection of services, it's inhabitable. I mean, we won't even get into the risk of staying in a building where there's no running water. It's a health hazard within itself. So we see that the non-payment of levies is highly linked to a body corporate that is unable to collect and to move forward in terms of growth. That's sinking the scheme down. So if a scheme is not collecting its levies, you'll see that it can't pay its security, it can't pay the wages of the employees of the body corporate, and can't keep with the general upkeep of the scheme. I know my colleagues would like to add on this before we move to the second slide. Lauren? Nothing from my colleague. Okay. I'll move on to the second reason why the scheme will go under administration, and you'll see that here there's a decline in physical appearance of the scheme. So in terms of Section 3 of the Sectional Title Schemes Management Act, Section 3(1)(l), it says that the body corporate must maintain all common property and keep it in a way that is good and in a repairable state. And this responsibility must be fulfilled by the scheme. And when we say the scheme or the body corporate, everyone is involved. We include the trustees, we include the managing agent, we include all owners. And that obligation in terms of Section 3 can be fulfilled with the payment of levies. I mean, you can't maintain a scheme and keep it and make it habitable and in a state of good repair if there's no money to do so. And we see that if a scheme is deteriorating because of lack of maintenance, like plumbing, like painting, waterproofing, general repairs, the scheme doesn't look good. And on the outer surface and internally, you'll see that insurance claims will start to rise. For an example, if there's a flood during a rainy season, and then the owner's roofs leak because of insufficient waterproofing, this causes frustration for owners and it causes discomfort. And not to mention, when you continuously claim on your insurance, the premium goes up. And that's kind of like a vicious circle. You don't have money to do the repairs, the scheme doesn't have the scheme continues to claim on the insurance premium goes up, etc., etc. So it's a vicious circle of non-compliance, and the scheme will then just deteriorate. So the lack of maintenance is a huge indication factor that a scheme will need to go under administration. And it schemes that don't have good maintenance or even a 10-year maintenance implemented, it decreases the value of the property, and it discourages prospective owners from purchasing in the scheme. So we see that schemes that are in dire need of some maintenance, not only just a coat of paint, but a maintenance fund that needs to be budgeted for by the scheme, and a 10-year maintenance plan that needs to be thought out and implemented. And we also see that most schemes don't have the 10-year maintenance plan and don't know how to start to build the funding for the maintenance plan. So the decline of physical appearance of the scheme, it's multifaceted, and it's not only coming in one direction, but it manifests in many ways, as I've elaborated. The third element that we will see schemes going under administration is a administrative mismanagement of the scheme's affairs. So the authority on how a scheme or a sectional title building should be run is found in the Sectional Title Schemes Management Act. And the Sectional Title Schemes Management Act, along with its rules, along with its regulations, are the blueprint of how to run a scheme successfully. The Act tells you, or tells managing agents, it tells trustees and also advises owners on how a valid AGM, SGM must be held, and the proceedings and outline of these meetings. And you will see in the Act that it's broken down very easily, and it's very digestible for people to see how to meet a quorum, how the agenda should look, and how to vote, etc. But you find that there are some schemes that do not hold this blueprint, and they don't execute the rules and the regulations. And from a legal point of view, the decisions that are made in the AGMs or SGMs that are not held according to the rules and acts are invalid, or the decisions that are made are not validated because of the way that the meeting was held. And we see in most schemes that the decisions are made and they're implemented. However, they are not valid when we do the compliance check of the scheme. So you have maybe a scheme that does not hold their AGMs timelessly, or delays their AGMs because of the incomplete financials, audited financials. And here, this is a strong indicator that something is wrong with the scheme and something may be amiss. For an example, say a scheme does hold their AGM on time, but it's not held according to the prescribed legislation. For an example, quorum isn't met, and the people that are running the meeting are not educated or well-versed to know what the legislation says on quorum, and they go on and they raise the levies and they implement a special levy and they elect trustees and so on and so forth. With this meeting that is not compliant, it has a
Veronica,
ripple effect. Yes.
I want to give an example. Sorry
Okay.
that I interrupt you. I've had an email yesterday from a scheme that actually came to Stratafin and was asking about what Stratafin does and how we can assist them. And in this email, this person that avers that he is a trustee or the chairman of the body corporate says that they've decided to change the way that their levies are levied, and they're now going to charge all units equally in respect of these levy contributions that needs to be made. I then ask, are these units different sizes and have they got different PQs? And he said, yes, there are 3-bedroom units and bachelor units and 2-bedroom units and so forth. But they just merely decided at an AGM that we're now going to distribute the budget over all units equally and no longer in terms of their PQ. So this is one of those matters that you are talking about where there's administrative mismanagement, where they just decide to do whatever they want because they have a lack of knowledge and they don't understand actually how levies should be calculated and how it should be apportioned to the scheme. And that's a very, very real life example. I mean, it came from one of the owners on Sectional Title Living South Africa, and then he started conversing with me and then started sending emails to Stratafin requiring assistance. And this is what's happening. So this is what we see in practice. Sorry that I interrupted. I just thought it was an apt example of what you are just trying to describe.
Thank you, Willie. And also to piggyback on that point, it becomes very difficult for an attorney to collect on the arrear levies if the decisions that are made at these AGMs are non-compliant. Because if an attorney is mandated to go to court to recover the arrears, they need to provide the valid and compliant evidentiary support to collect the levies. So if the AGMs are not compliant and the decisions that are made are not done according to the blueprint, which is the Act, the rules and the regulations, it becomes a pain and merely impossible to collect on those arrears using the court system. And we see that there are queries that are raised by magistrates to say, can we please have the minutes? And you'll see the minutes and there wasn't a quorum, or the voting cards for a decision and there's no voting cards, and it was still done, the voting was still held by raising of hands. And we see in the new legislation that the legislator requires voting cards. So it might be minuscule compliance errors, but it leads up to a bigger cause of not being able to collect the arrears, which the scheme needs that funding to move it forward. So a monitoring on the compliance is extremely important, and the main reason where, as Billy said, that we see it in life where managing agents and trustees don't know how to follow the Act, and they come to us and they ask us, how can we resolve this and how can we resolve this? Another point to make at the the lack of administration, mismanagement of scheme affairs, pardon me, is the lack of monitoring of the municipal accounts by the scheme. And this is very, very important, because if you don't monitor the scheme's municipal accounts, you'll find at the end, maybe 2, 3, 4 years later, the arrears have built up and become so unmanageable. And the scheme has, the local municipality has not been out to do readings, and they're billing the scheme estimates, or they are billing the scheme on the incorrect rate and the incorrect tariff. And resolving and the lack of monitoring these issues make it so difficult to resolve. And the worst case scenario is that the scheme is disconnected of its water and its light. And that is the downfall of most schemes. When the municipality switches off the lights, it's very unlikely that the scheme will then come back up without having the correct services of a person that can attend to the monitoring of the accounts and fix all of the incorrect billings and tariffs on the municipal accounts. So we see that schemes need to monitor their municipal accounts, and that is one of the reasons that a scheme will go under administration, is that municipal accounts errors, very, very common. Then you will see that sometimes there's a misappropriation of funds. This can, you see it across the board in terms of body corporate funds. Perhaps there's loaning of money, scheme monies to other members, or funds are not used for the expenses that they are allocated to. Funds go missing, and this is obviously a huge problem within schemes, because the schemes funds are there to maintain the scheme, to build up the scheme, to ensure that the expenses are paid, quote unquote, the lights are turned, are kept on. And if there's a misappropriation of funds, there's a non-payment of the expenses that those funds were allocated to, and then it's a whole ripple effect. And eventually a scheme will crumble and fall if the misappropriation of funds keeps happening and lead to the downfall of the scheme. So it's very, very important that if a scheme is, the funds are dwindling and they are not being used for what they meant for, is to consider putting the scheme under administration and have that part of the elements at least resolved in that way. Another point that we see, another reason that we see schemes going under administration is the lack of leadership and decision making. So between the managing agent and the trustees, they are the glue that keeps the scheme together. And you'll find that if there's a lack of decision making between the trustees and the managing agent, the scheme doesn't move forward. No decisions are made. It's very difficult for things to progress, and there's a delay in the overall movement of the scheme and the progression of the scheme. This symptom will manifest mostly, and we've seen this at an AGM, it becomes time to elect trustees. And it's either there's no nominations, or the same trustees are re-elected over and over again. This causes a succession issue, pardon me, in that the scheme's affairs don't get succeeded from one set of trustees to the next set of trustees. And even worse, when there's no nominations and everyone just adopts a hands-off approach to the management and the running of the scheme. And this is a recipe for failure. And other cases of lack of decision making and leadership is infighting between owners, where some owners want to push their individual agendas and other owners have other agendas, and the meeting of minds isn't there. And this causes difficulty in running a scheme forward, and it takes away from the necessary power to move the scheme forward. So the Board of Trustees are the leadership of the scheme, and they are the forward momentum that's necessary to move the scheme forward. So another element maybe of lack of decision making is not being knowledgeable enough about Sectional Title Schemes Management Act, Sectional Title Scheme Management. And this can cause the downfall of the scheme. Maybe if the trustees are not knowledgeable enough about the management of a scheme, and they don't listen to the advices of the managing agent, or they do not get insights themselves in educating themselves and make detrimental decisions towards the scheme, it becomes problematic. So in highlighting these reasons, we can see that an administrator would be the saving grace to these problems, as the administrator will step into the shoes of all the owners, represent all of the owners, and if there's infighting, will disembark those factions. And if there's problems with decision making, the administrator will be the one that makes the decisions. And at Confiance, we have a scheme. Just pardon me, sorry.
What happened there? Veronica,
Sorry, I was coughing.
sorry.
Sorry.
Can I, while
Yes.
you cough, can I just quickly jump in?
Yes.
Where there's infighting, it normally happens where people don't have the necessary knowledge. And at Stratafin, we decided to actually start our trustees training portal, and also, it's an owners and trustees and managing agent portal, which is available on our website, and it's free of charge for people to actually get trained to understand what their obligations are, what their rights are, and so forth. And we believe that if one does that and you get that training, that you would actually be in a better position to lead and better position to understand what is happening when other people are leading, and don't see it as an attack on you or on your property when they are doing what is required in terms of the Act. So it's important that people start to educate themselves. I mean, this is why we're doing these webinars, is so that people can educate themselves and understand what the rights and obligations are in terms of the Act. Sorry, Veronica, I jumped in again.
No problem. You gave me some time to cough. Thank you. Yes, so an administrator comes into the situation to correct everything. Literally from the maintenance to the financial problems to the infighting to the lack of statutory compliance. We do everything, and we educate owners, obviously, when we are appointed as the administrator, that we will we will try our level best. Being an administrator is not an easy job, but we pride ourselves in commitment, taking the time to assess the needs of the body corporates and rectify them. I just see a question on the chat that I just want to answer, and then I will hand over to Hendrik, who will do the second part of the webinar with regards to ways to fix this. So anonymous attendee has says that their scheme was rezoned and it was backdated for 4 years, and yeah, this places a huge financial burden, and how can we resolve this? Confiance can assist in resolving this this issue. We do have a municipal department. It's Mr. Brits and Mr. Veronica, who are well versed in sectional title municipal queries and questions, and can assist you with that. So at the end of the webinar, you'll see our contact details and you can email us and we can see if we can assist you. That's from my side. I'll give Hendrik to lead the how Confiance can fix these problems and help the scheme regain its financial stability. Thank you, Hendrik.
Morning, everybody. Thank you, Veronica. Appreciate it. Yes, within the Stratafin group of companies, we have a lot of skills. We have a lot of experience to deal with this. The problems that I'm sure that you can relate to, that Veronica is sketching now for us. I do not believe that one of the people that has joined us that would not be able to identify with some of it to a lesser or to a more extent of this. Now, we normally follow an approach where if we want to rehabilitate a scheme, we look at compliance first. We do an onboarding process. We look at what has been complied, what is not. We do a complete compliance audit. And then we start with a gap and with what we have and check the quality of that. And then we start managing a scheme. So, ladies and gentlemen, the rehabilitation or the rescue of a scheme is very similar to a business rescue process in concept. Though it's a different background, different legislation, principles are quite similar. We look at levies. Levies is absolutely the lifetime or lifeline of any scheme. Veronica has told us about that, and it is really the root of most problems that we experience with schemes. If you look at compliance, once again, the first and foremost thing is, are levies legally raised and are they collected? Do we look at collections? Are they actually being collected? Is there a collections process underway, a policy? And what debt control measures have been and will be implemented? Are debt collection measures being budgeted for? Very important. Can't collect levies and start a legal process in that regard if you have not debited and let's say a vote on your budget so that you can cover that expense. Because without that, I'm sorry, you're going to be delaying your whole process, which is totally counterproductive. So, ladies and gentlemen, the question is really also, would a body corporate have the resources to manage their financial records efficiently? At Stratafin, at Confiance, we do have not only the knowledge, but also the expertise and the capacity to manage the finances of a body corporate on a daily, weekly, and monthly basis. Where necessary, when we take over a scheme under administration, we will also take the necessary legal action. Obviously subject thereto that the budget for such is available.
Hendrik, can I just,
Yes,
can I just
please,
come in here? Can I come back in here? Sorry. I see that a question was asked regarding CSOS, and would you rather go regarding the collection of the levies? Would you rather go the CSOS route or through attorneys? So we hear the whole time that CSOS is for free, and it means it's actually a prepaid system because everybody pays towards that. If you're compliant or non-compliant, it doesn't matter. You have to pay a monthly amount in respect of your CSOS levy, and that then gives you access to the CSOS mechanism. However, CSOS, the adjudication process that goes through CSOS gets an adjudication order. That order is in exactly the same position as a default judgment. So once you've obtained your default judgment, you have to go through the rest of your collections process. And unfortunately, CSOS does not cater for that at this stage. So one then moves the matter from the CSOS order to the High Court or the Magistrates Court, depending which court you decide to go through with this collection. And you have that made in order of the court, and then you would take the necessary procedure through that specific court. Now, a default judgment would not even amount to 10% of the cost of a collection matter. So the amount that is saved by going the CSOS route is maybe 10% of your collection cost. The majority of the collection cost, about 80% of that, lies at the end of the process when you sell the property in execution. So you obtain your Section 66 Magistrate Court order for the right to sell the property, or you obtain your Rule 46 order in the High Court to sell the property in execution. You then advertise and you then have the sale through the sheriff. So that is the majority of cost in respect of a collection matter. So you save very little going the CSOS route. And from our point of view, we have seen many orders by CSOS which are questionable, and which we've taken on review, and where the High Court has set those orders aside. So from our point of view, we would rather use the courts when we do collections. To us, we are then more certain that we are in a controlled environment where we know what's going on and what the outcome should be, because there are precedents and the courts have to follow these precedents. So that is just in respect of that one matter. So sorry about that, Hendrik. I just thought that whilst you were talking about the collection, and then also we were asked if we're going to have a discussion regarding HOAs. So HOAs work in a very similar manner, but then you will follow the business rescue process. So depending on what form or type the HOA is, but we will have a discussion regarding that at a later stage. Yes.
I think that was a valuable contribution, Willie, because it's a fair question and we often get that question. So yes, definitely, ladies and gentlemen, you need to understand the process. You need to be able to control the process, and you need to have the money to do that. Which brings me to another point, in that if a body corporate does not have the funds immediately available to pursue legal action, Stratafin most certainly has some products that would assist you in funding those processes. And yes, very definitely we can assist in that regard as well. So part of the takeover and the administration process would also be the control over bank accounts that need to be taken over. Sometimes you find that the banking would be resorting under a trust account, which we do not favor. We prefer separate bank accounts, and if we encounter such a case, we will then open a separate bank account for the body corporate in question, so that we can properly control and report the finances and the movement thereof on a monthly basis. We also ensure that we do financial monthly reports to the owners committee. We open communication channels to ensure that we have transparency of the scheme affair. We make use of platforms like We Connect You, which we find very useful, and a liaison committee consisting of owners is therefore then set up to assist with two-way communication from the administrator on our intentions and what we do, but also getting feedback from the scheme's owner in that regard. We also evaluate an audit service provider and the various relevant contracts to ensure that the scheme is provided with efficient and affordable services on an annual basis. Ladies and gentlemen, and that is also one of the reasons why financial statements must be drafted and audited, so that proper control and report back in this regard can be given to the various owners, and that the scheme and the body corporate would know exactly what the status of their ownership in this regard would be. Also make sure that the scheme is registered with CSOS and that the prescribed levies are paid. It would seem a trivial point that we have found in the past that schemes are not registered with CSOS, which is, well, first and foremost illegal, because it's a prescription in law and you don't have a choice in that regard. But yes, definitely, we try and ensure that schemes are registered with CSOS. It is part of the transparency environment, and we also report into CSOS on a quarterly basis what we are doing at the scheme and what our progress would be. Now, if your scheme is
To
compliant,
add, sorry, Hendrik, just
sure,
to add
sure.
on the topic of compliance, is that we still execute the act as if the body corporate is still within its trustees in terms of holding AGMs and advising owners according to what the administrator is doing with the scheme. And it's not only a one-way street where the administrator is just rehabilitating, but we at Confiance hold the AGMs as per the act and invite owners, even though there's no decision making that they need to know or need to make, but we advise owners on how the scheme is being rehabilitated and also ways that they can assist themselves as owners in protecting their investments. So we also, as administrators, follow the statutes on how to do things the correct way. Because imagine if the administrator who is court appointed is not following the legislative templates on how to do things correctly, when the scheme is no longer under administration, the owners will also follow the incorrect way. While I'm also here, there's a question on the chat that asked, how does a court in the case of Section 16 application decide on who the administrator will be? So how the appointment of an administrator works is that when you bring the administration application, you suggest to the court who you want the administrator to be. So you don't bring an application to court to say the building should be put under administration, then the court decides who the administrator will be. So it works the other way around. You make a recommendation to the court that this is who you'd like the administrator to be based on what the work that they've done, their credentials, the team, and their success rates. And then the court will either grant that application or will refuse the application.
Veronica, before we step off that, but we have seen now where a different process was followed. I think that your appointment the other day by the court, by the High Court, was one of those where the court followed a different process. So in that instant, the court referred it to CSOS to then recommend somebody to be appointed as an administrator. CSOS then contacted Confiance and contacted Veronica, knowing her as an administrator in the industry, and required a full audit of credentials and what she's done and what scheme she has administered and the success that was achieved in that. And they then prepared a report for the High Court, and that was then given to the High Court, and that then decided to appoint Veronica in that specific matter. So although Veronica is correct that an applicant normally says, this is the person that I want to be appointed, we have now seen where it happened differently, where the court referred the matter to CSOS to actually nominate people and then appointed the person that was nominated by them.
Yeah, quite correct, Willie and Veronica. An administrator is not a law unto their own. They're not a sheriff riding into town and who makes up their own rules. They have to follow legislation. They are appointed under the said legislation, and we must execute our duties as it would have been by the trustees. So it's the same thing. It's just one body instead of a committee of trustees. Now, we've also seen, Veronica alluded to this, that schemes are often in financial stress due to the under-recovery of municipal utilities. What we do when we take a scheme under administration, we assist with putting together a payment plan with the municipality to ensure that at least the current account is immediately paid and the light stays on, as she had made mention of. We would also then negotiate an agreement to pay arrear debt if there are any, and we often find that that is the case, that there is huge arrears on the municipal accounts of schemes that are under duress and in financial stress. And we assist with that as well. Then we also audit the municipal account at Confiance. We make sure that the correct tariffs are applied, that tariffs are applied in the manner that they should be. And we look at the utility account to make sure that the services are delivered against the tariffs that is properly promulgated by the municipalities, and no less. We would also make sure that the utility management at a scheme is properly managed, and it is always a priority, so that we get the living unit usage as well as communal property usage managed and controlled. Look at possible distribution losses, if there are any prevalent that we can prevent. And we look at prepaid meters often for assistance as a measure. Prepaid municipal meters would often help also with the credit control of a scheme. When we apply to court to be appointed, part of our application also includes the ability to do credit control through the prepaid system. In other words, if you do not pay your levies, you're not allowed to make use of municipal utilities.
Hendrik, if I can just come in here. In general, a body corporate would not be allowed to actually go and cut electricity or water supply to a member when there's non-payment, because that would be seen as spoliation. So the court and or CISOS will immediately grant an order where that person is then put back into possession of the electricity or the water or whatever service has been taken away from the owner. So in terms of if you do the application correctly and you require in your court order that the court then orders certain things, which we do, we would then ask the court to grant an order that says that the arrears should be paid through the prepaid system, and unless that arrears are paid on the agreed or at the agreed amount, that the owner will then not get access to a payment of current account. So they won't be able then to purchase electricity or water, or whatever the situation might be. So that then forces them to pay the arrears. Those amounts are then utilized to pay the municipal account that is in arrears, and the current is then paid out of the current usage of the owners. So in that way, one then gets them on a path to rehabilitation. I've also seen that somebody was going to pay 400 Rand a month, which equates to a payment over 21 years. So that would absolutely be not acceptable. One cannot have a payment plan where somebody pays over a 10-year period. When we enter into payment plans with people, we would do that generally for a 2-year to a 3-year period, and not longer than that, because if it's longer than that, it actually is futile. The amount is so little that it actually will never pay the debt off, or takes that long, 21 years. So one would then proceed, if you get an offer like that and the person is not prepared to give you any other substantial offer, one would rather then proceed with your 46 application to declare the property executable, and you would sell the property in execution and recover the levies during that process, and then hopefully have a new owner in place that will then pay levies. So one does not need to accept a ridiculous offer. you want to enter into offers or into payment plans with people. I mean, one wants to do that as often as possible, but not to the detriment of the scheme. And this clearly is something that would be in the detriment of the scheme. You can't allow somebody to pay that little. And if they still then don't pay their current levies, then what are you going to recover? It creates a huge problem. Then I'll also see that there's an affordability problem. The fact of the matter is that if somebody buys into a scheme, and it might sound harsh, but if somebody buys into a scheme and they cannot afford to pay the levies, then the better option for them is to rather sell their unit, move to a complex or to a freestanding property where they determine themselves what will be maintained or not maintained and so forth. Because if you are part of a scheme and you do not contribute, you are actually causing damage to the other owners that are compliant and that are paying, and now their properties and the common property cannot be looked after because you're not paying. So one does feel sorry for people that can't afford it, but the fact is that as a community scheme, everybody has to contribute towards the upkeep and maintenance of that. And if somebody can't then maintain it, they need to then either sell themselves, or at the end of the day, if they don't contribute, the property will be sold in execution through the court process.
Excellent. I agree with you, Willie. The knock-on effect of non-payment of levies is so immense that it leads to the destruction of a scheme eventually, if you do not turn around the scheme by means of a rescue attempt, which administration, obviously, in our opinion, is the best way to do it. Yes, and then we also look at the exclusive use areas that may or may not be registered, and we look and check if they are properly registered and if there's proper accounting regarding that. Because if there's an exclusive use area, an owner is responsible for the upkeep of that as well. So, compliance management. I think if your scheme is compliant, you are already on the way to turning it around. That's why compliance and the payment of levies is such an important matter. The goal of an efficient body corporate is to be in good standing with both the municipality and all its other creditors, so that it could also then execute its duties. Every scheme needs to have rules, and those rules in place must be registered with CSOS. Where necessary, if there are current rules, they could be updated if they are outdated to cater for new needs and the peculiarities of a certain scheme. Here we look at the differences between, for example, a block of flats and freestanding units in a townhouse complex, or that are linked in terms of communal walls. So rules address these unique features. For example, and this is just a few random examples. Parking, pets, pools, communal braai facilities, clubhouses, the installation of solar, which is a very, very hot topic at the moment, the use of generators during load shedding, and another matter that has reached the press from time to time is the matter of traditional slaughtering. So it is always better to have rules in place, because good fences make good neighbors. And if there are rules that guide how you must conduct yourself and how the scheme must be managed, then I think there is order, and where there's order, there's also good relationship and coexistence. So you must remember, ladies and gentlemen, and this is more to owners than possibly the people who manage schemes, but owners are co-members of a scheme, and therefore they need to coexist. So therefore rules are extremely important. We also need to look at the reserve funds that must be built up for emergencies, amongst others, as regulated in terms of Regulation 2 of the regulations of the Sectional Title Management Act. Insurance, another legal requirement that is prescribed by Regulation 3 of the Sectional Title Management Act. Often we find that schemes that are in duress will have flaunted their insurance, which is a very, very dangerous practice, especially if a calamity happens. So the insurance claims history will also tell us what maintenance issues are already prevalent at a scheme. And given this, as well as an evaluation that I'll talk about just now, will give us an indication of what your maintenance plan would be, and that will inform your 10-year maintenance plan that is also prescribed. So maintenance is one of the things, together with insurance and the municipal bill, that immediately suffers when a scheme goes into financial stress. Short payments, wrong payments, irregular payments all contribute to that. What we do when we take over the scheme is we will do a complete assessment of the physical condition of the scheme. In other words, what do the buildings, communal areas, and assets look like? We get a properly registered professional to assist us with that so that we have an idea of where the problems lie. We quantify the address of that problems, how to repair, how to maintain in future. And this all informs a maintenance plan that must go into the scheme's budget. That informs your 10-year maintenance plan. And we also look at the management rules. I want to refer you to management rules 29 to 31, which deals with the physical upkeep of the various assets of a scheme. Very important. I find in practice that people just flaunt the maintenance of the scheme the moment that finance is becoming a problem and when people do not pay their levies. That deteriorates the value of the individual owners and the owner's investment in that scheme. So an improved physical appearance will also assist with adding value to the scheme in terms of what a unit would be worth and what an owner can sell it for. Then, ladies and gentlemen, Veronica had quite a lot to say about effective leadership and where it goes wrong in decision making. I need to stress lack of training and knowledge of trustees is adding to management problems, financial problems, and the like. And at Stratafin and Confiance, we aim to help the various schemes train prospective trustees, train owners so that they are knowledgeable, because knowledge will lead to confidence in administering and managing your various scheme matter. And in that way, we create a healthy environment where owners could then, once the administration period has lapsed, would then be able to elect trustees again and continue with managing their own units. We strongly advocate the use of liaison committees whilst we are busy with the administration of a scheme, because it leads to practical knowledge on how to manage the scheme, and the two-way communication that we have with the various owners then serving on such a committee is then very valuable, not only for the administrator and getting feedback on what is required or what the needs are from the individual owner, but also the people that are members of that committee will then see how we go about in resolving and managing issues. And our objective is to instill leadership and knowledge of owners and trustees to ensure that in the end, a scheme is compliant and financially stable. Ladies and gentlemen, I think that is the end of my presentation as it is. Perhaps we can take a number of questions.
There was a question, and specifically, the question relates to administration and executive managing agents. So Veronica, do you want to just address the difference between an administrator and an executive managing agent?
Not a problem, Willie. So an administrator, in terms of Section 16, is appointed by the court, and this administrator will step into the shoes of the trustees and will also perform the managing agent function if need be. However, the managing agent and the administrator can also work together. We do have situations where we are appointed as the administrator and there is a managing agency as well that we work with. And then with regards to executive managing agencies, that is process that's outlined in the prescribed management rules. And it sets out that a resolution is needed to appoint an executive managing agent. I think it's a special resolution if I'm not mistaken. So a voting needs to take place of who this executive managing agent will be. And an executive managing agent, in a nutshell, will then perform the duties of the trustee. So when there's an executive management agent appointed, the trustees will cease. And then I've also seen in situations where there's an executive managing agent and a managing agent working together, and they cooperate into propelling the scheme and running the scheme forward. So
yeah,
yes,
so the
Willie?
difference is that the one is appointed by the court, because there was an creditor or an owner or a board of trustees that applied to the court and said we can't manage the scheme and the scheme is dysfunctional, and appoint somebody to now step into the shoes of the trustees and in the shoes of the owners. So they then become the sole person that manages the scheme and make decisions regarding the scheme. Owners and trustees don't make decisions anymore. Where with an executive managing agent, it is appointed by the owners themselves. They make a vote that they want to appoint somebody. The executive managing agent step in the shoes of the trustees, and they make the decisions that the owners allow them in accordance with the budget, and the decisions surrounding compliance and so forth. So there are a difference between the two. So that is the basic difference between them. So the one acts in accordance with the court order and the other in accordance with a decision by owners.
And just at the back end of that question, they asked, where does the managing agent's responsibility start to recommend the estate should be under administration? So Section 16 says that an owner, the local municipality, or a creditor can approach the court to place the scheme under administration. So it's very unlikely. I've seen it once since I've been administrator, where the managing agent is actually recommending that the scheme be placed under administration or bringing the application or supporting the application. So if you look at Section 16, it gives you a category of people that can approach the courts in terms of bringing this application.
Perfect. I think those are all the questions that we had.
Here's a question to Hendrik. Sorry, Willie. To Hendrik, it says, maintaining the aesthetic of the estate. Some people want to mount things onto common property walls, such as garden hose pipes, basketball hoops, walls, and etc. What part of the legislation governs or not allows this? Governs not allowing this?
Yeah, so I will deal with that. I mean, the Sectional Title Schemes Management Act and the prescribed management rule determine how people can affix things onto the common property, because at the end of the day, it's common property and you cannot go and do that. I mean, we've had extensive discussions on other webinars about the roofs and solar installation and what vote is required to actually allow for these type of things. So it has to go to the Board of Trustees. There have to be a decision taken how this will be allowed, and who will maintain those things, what will happen when they are removed, will the scheme be placed in the same situation, and so forth. So what we'll do is we will just refer in the emails to the specific management rule, and we'll give you the outlines of that specifically.
In fact, we dealt with a similar case yesterday. So yes, we will answer that specifically.
Yeah.
Thank you very much.
Oh, sorry, there's another one. Can an owner sell? Because that was one of the misconceptions that we've had. I mean, we've and it was something that I wanted to discuss actually, and I forgot about it. Can an owner sell in a scheme that's under administration? Absolutely, yes. There's no reason why somebody can't sell whilst the scheme is under administration. In actual fact, sometimes it makes it much easier to sell because the administrator will act in accordance with his appointment in terms of the court order, and will then issue the clearance certificate. And one will see sometimes that where the scheme is not under administration, there is this infighting. You have more than one board of trustees. I mean, we have schemes under and the administration, where there were 2 or sometimes even 3 boards of trustees, or calling themselves boards of trustees. So nobody would know where to get their clearance certificate from, pay it into the right account. Different managing agents managing the scheme, coercing owners to pay to their accounts. So in that instance, it does become easier to get your clearance certificate so that you can transfer. So there's no prohibition on the sale. If you will, however, get a bank to finance that, I don't know. In general, when we take over the administration of the schemes through Confiance, we do see that those schemes get put onto the right tracks, and hopefully in time they will be sorted out completely. And then you will have sales, and you will have increased values as well, because now the scheme is run properly, the rules are in place properly, levies are correctly determined, maintenance plan is in place, maintenance reserve is being built up, and so forth. And in those instances, and the scheme is being maintained, and in those instances, you will then see that people will be able to sell their properties far more easily, and will get their money that they've paid for their units, and the growth of their property values. Thank you, ladies and gentlemen. I think that's what we've got time for this morning. We really appreciate you coming on board to listen to us talking about administrations a bit.
Thank you, everyone. And just to let you know, we will take note of all the questions, and we'll be posting answers before the end of next week. We'll email them out.
Thank you, everybody.
Thank
Thank
you.
you.